is here today. We are in the third part of the purchase agreement. We can't wait. We've had a fabulous 2 days of training. This is the third day. We have Miss Denise Waters, 20-year broker, that's going to kind of go through the third part of the purchase agreement. So without further ado, I'd like everyone to give Miss Denise Waters a hand.
Thank you very much. Thank you for coming to our training session. Today, as Michael mentioned, we'll do session 3. We're going to pick up on page 4, 10C, withholding taxes. Page 4, section 10C, withholding taxes. Okay, we're going to go to the first slide. So for the withholding taxes, the escrow company will withhold the tax. The buyer is technically responsible for it, but escrow facilitates it. So there are 2 taxes that are withheld. There's a federal tax and a state tax. The federal tax is under the Foreign Investment Real Estate Purchase, Real Property Tax Act, FIRPTA. You've heard that many times. Federal law has been withholding 15% if a person is identified as a foreign person. If the house is less than $1 million and they're going to live in it, then the amount is 10%, so it's less. In the case of California, it's 3 1/3% the withholding. If the property is not owner-occupied, if it's owner-occupied, then Internal Revenue Code 121 dictates and there's an exemption. But escrow handles this for the buyer. Typically, if the property satisfies certain requirements, there are exceptions. And those exceptions, as I mentioned, the principal residence, if the property is less than $100,000, or if it's a 1031 tax-deferred exchange, which is a tool that investors use. If at any point, of course, if you have a question, stop me and I'll answer. If the exemption is going to apply, the seller has to provide that information to escrow on behalf of the buyer. Withholdings continued, as I mentioned, since withholdings are required by the buyer. That's the only way to give teeth, since the buyer is providing the money into the transaction. In the case, the normal way, or one way, is the disclosure form AS, which we could prepare as a car form. You could do that, but a lot of times the sellers don't want to do that, use that form, because they have to disclose their social security number. So the escrow office can do the form on behalf of the buyer, and that's when you get the form QS. A lot of times in your buyer's escrow in your seller's escrow package, they'll have that form in there that the escrow company will prepare, and that's the form QS. There is an exemption for the California withholding that property sold for less than $300,000 if the buyer lived in it, then they can do a form AB, and then we're required to retain that information for 5 years. There's a couple other disclosures. A lot of times we get hung up, I think, in the buyer's investigation with the property inspection and the natural hazard disclosure report, but there are other things that the buyer can look at. One of them is the Megan's Law database, which we know that kids are, we have pedophiles out there, and so for those particular situations, the buyer can actually look at that website and identify who in their area, what people that have had sexual predators are in their area. So they can do that. The other thing is for gas pipelines. Sometimes we forget about that, but pipes do explode from gas and those kind of things, so a buyer may want to know that before they actually make a purchase. Condominiums, love condominiums. We talked earlier about some of the disclosures, but one of the things is in the seller's proper questionnaire, one section that you have to disclose if it's a community property. So if it's a condominium, a planned unit development, or some other situation in which it's community living, so the buyer knows for sure what they're buying. And so they would do that in one of those 2 documents. Also for the community living, we talked about there's some disclosures that the seller needs to provide to the buyer. One, the CC&Rs, we talked about the minutes. If there have been any litigation against the complex, they need to know that. If there's a special assessment, about to take place. That would normally be identified in the minutes, but the owner needs to disclose that because all of those are going to have financial impacts to the buyer. There's a form HOA. I found in most cases, though, that form isn't very helpful because it has a lot of stuff on there. Nowadays, my experience has been that if it is a community environment, most of the time the listing agent is going to go online because many homeowners associations are slowly but surely getting to the point where they're able to do those and then have either a third party or something that's providing the information back to the escrow company. And also, since those documents are typically paid for by the seller, a lot of times you'll have to pay the money up front to get those ordered. So if the listing agent is ordering it, some listing agents provide that as a courtesy to their clients. But in either case, the seller needs to be prepared to pay for those up front. Okay. Condition of property, as is. We always hear that all the time. It's as is, it's as is. Well, there are certain things, even though it as is, that the seller is required to do. The seller is not required to make any repairs, and we'll talk about that further. But they do have to disclose any material facts, and those material facts will be disclosed on the seller property questionnaire. Insurance, sometimes we may not remember to check that, but insurance is a big deal because if there have been a number of insurance claims against the property, then it may not be insurable. So that's one of the things to pay attention to. Some lenders pull the report, I think I have it defined in there. There's a database, just like we have the database for credit reporting. Now the insurance companies have a database and they all feed the information, and it's a comprehensive, I have the name defined a little bit later. I don't want to butcher it. I know it's a comprehensive liability something, but I can't remember the exact. So you want to make sure that you know that. And the other thing about condition of property, at closing, the property has to be in the same condition it was at the time the buyer made the offer. The buyer. Buyer is responsible in terms of condition of property, reviewing those disclosures that the seller provides, and then performing their own independent property evaluation. And we addressed that early. It's addressed in paragraph 12. And then the buyer can ask the seller to make repairs, but the seller doesn't have to. The buyer can cancel the sale as long as they're still within the inspection period. If it's customarily it's 17 days, but it could be anything that you write in. So if you're still within that period and you and the buyer and seller can't come to an agreement, then that is one of the provisions which the buyer can cancel the agreement. There we are. The comprehensive loss underwriting exchange. That's the database that all the insurance companies are feeding into so that they can know, the lenders can know the condition of the property if there's been any major things. Like the people who are having the flood issues out there, I'm sure that if that house gets sold later, they're going to be checking that report to make sure that if there was a claim against the property, inspect the property to make sure the work was done and that kind of thing so that they know that their investment is protected. And then one thing that I learned, which I did not know, that clue report is now free because in days gone by they used to charge for it. So it is free, but only the seller can order it. So you can always request through your disclosure period or your contract that they provide a clue report to you so your buyer can review, and they can get one once a year. The other thing is buyer beware. So the property may not have been built to code. All those things have to be investigated. Some buyers go over to the city to look at permits and other things on the property to make sure they fully understand what they're buying. And sometimes I, as an agent, will help my client by going over there with them, or sometimes if it's a seller, I will go over there on behalf of the seller to pick up the information, and then we come back and we discuss it. So that's very important to know.
I have a question.
Yes.
Can we as agents go representing our clients to get those permits pulled out from the city, or?
The permits are public record, and so yes, normally you can pull the permits that are on file on behalf of your client.
Broker note on that. Be very careful about pulling permission yourself, because if something's wrong, the liability is gonna fall back on you. Because they're gonna say, well, who pulled the permits? Well, my agent did. You follow what I'm saying? So you wanna be very careful about doing that. My recommendation is to have the seller pull the permits or either go through a third party. There's third-party companies that will pull the permits for you, so therefore you don't have any liability in it at all.
Michael, just to make sure I'm clear, so that's for if there's work to be done for the pulling of permits for new work, or actually just pulling existing permits?
I would say for any of it.
Oh, okay.
I would say for any of it, you know, because you don't want to be responsible for them saying that you were the one that pulled the permit, you're the one that got the copy or whatever. I would just try to be as clear as possible.
Okay.
But definitely don't pull no permits if you're starting to get work done.
Oh, absolutely not. Okay, everybody clear on that?
Clear.
Okay. The buyer's right to investigate or inspect property is a contingency of the agreement. The buyer must remove all contingencies or cancel the agreement. That's one of the things that's set up front in the RPA. The buyer has the right to check just about anything as long as they do not destruct the property. They definitely cannot go to the city and request an inspection or those type of things without the seller's written permission in advance, because if there are problems with the property and the buyer does something like that, then the seller's property could be devalued, and we don't want to get in any situations like that. We talked about registered sex offenders, lead-based paint. We know that that's one of the disclosures. The other thing, the termite inspection. The termite inspection, there should be a licensed registered company. The report is normally divided into two sections, Section 1 and Section 2. Section 1 is existing infestation. Section 2 is what might lead to a problem. Classically, the seller will pay Section 1, but that's not always the case. So in the section, in the previous section where it says which party will pay, then you'll identify if the seller is to pay for something. Like if you wanted the seller to pay for the inspection report. In the earlier section that deals with reports, you could identify you want the seller to pay for the inspection report. Of course, today in a very competitive environment, you want to minimize the things that you ask the seller to do. So I would probably say just let your buyer, if there is a cost for the termite inspection, let your buyer cover that, and then try to negotiate the repairs at a later time. At least you got your foot in the door dealing with your competition. If the seller doesn't want to do any corrective work that's identified in the report, then of course the buyer always has a right, the buyer always has a right to cancel. The repairs for the termite work are identified in the request for repairs form, and you'll see a section in there for that. Limitation on the buyer's inspection, we already touched base on that from the standpoint of don't do anything with the city, and you can't do anything destructive to the property. As we continue on with the buyer's investigations, what's very, very important when we get to section 14, everything's about the timeline. So within the timelines that are allotted, we want to complete all of the investigations. Any reports that are generated on the buyer's behalf, the seller's entitled to a copy of it at no expense to the seller. And that actually continues on even after the transaction is over. If we didn't provide it and they wanted to try to force the issue, they still are entitled to that. We talked about no damage to the property while we're performing those inspections. And then this one we don't really get into much because most of the time it's not major work. But if there was some major work and the seller was concerned about liability, they would want to record that notice of non-responsibility which says that the buyer performed those and that's not against the seller. But typically that's when major work is being done. Title investing. Title company produces the preliminary report. That preliminary report is saying that they're considering issuing a title insurance policy. The buyer has to, during their investigation period, look at that report and then determine if there's anything that they want to take exception to or that they want additional information on. The other thing that happens during that period of time is the seller is required to do a statement of information, and that statement of information, the title company is able to go check the general index because they're looking for any judgments, etc., against the owner that may show up and create a problem or may need to be paid so they don't attach to the property. title investing continued for anything that's related to, like if it's a community development, et cetera, that also is going to be identified for CC&Rs, which are recorded against the property. If there are any liens other than the mortgages, the deeds of trust, then that will also be discussed. Except for in the case where the buyer makes the offer subject to the existing liens. Has anybody ever done a transaction subject to the existing liens? Okay. If some investors do those, so let's say that the seller had a property and the investor wanted to buy the property, but they only wanted to bring in the difference between the existing mortgage and what they were buying it for, then that would be, they would say then leave that mortgage in place, I will bring the cash for the difference, and then we'll close the transaction. A lot of times some sellers may be afraid of those because it's not a legal requirement, but it's a bank policy. Anytime that the property is sold and there's not a formal assumption, then they can call the loan due. So that's the flip side of that. They don't normally, but they can. So that's why some sellers may be afraid of those. But I personally have purchased property subject to. The house I live in right now, I bought it subject to from a person who was in trouble. So you can do those. Just need to make sure you know the rules. Let's see. As is, we talked about as is. Grant deed, most properties are transferred via grant deed. And has anybody had any properties that have transferred where the oil and mineral rights were reserved by a previous seller? Sometimes you'll see those where the property transfers and someone, not the existing seller has to transfer those to you. They can't pull them out unless the original agreement was that they get to pull those out. But if those rights were already removed from the property sometime in the past prior to this transaction, then they continue to stay that way. And then vesting, vesting is done through the escrow instruction. They identify to the, they give the buyer a package and the buyer will decide vesting, because that's very important. If you ever get down, if they ever get down the road and have a problem between husband and wife or brother and sister, those kind of things, how they took title is important. Or if someone passes away. Because joint tenants is right of survivorship, so it automatically will transfer over to the spouse that's still living. If they took it as tenants in common, then the other half of the, if it's 50-50, the other 50% can go to a different heir. They can will it to whomever they want to, so that's important to know for the buyer of the property. And that's why in the olden days, they used to identify the vesting in the purchase contract, but now they remove that, give the buyer a separate package through escrow, the definition of all the different types of ways to hold title, and then they make the decision themselves. The culmination of the process is going to be a title insurance policy from title, and that title insurance policy, there are two different types. They basically provide the same coverage. The California land title and the Alt-R. The homeowner's policy is available for natural persons, not for corporations or trusts or anything like that. Time periods. This is the critical part for us because this is the part that, one, determines our buyer's liability if we're dealing with a buyer, and their money would be in jeopardy if we don't get all of these steps done to make sure that they complete their investigation in the proper timelines. So for each contingency or contractual obligation that's stated in paragraph 14, and paragraph 14 is on page 6, for each of those we have some specific guidelines. So at the culmination of the process, we're either going to get rid of the items by the contingency removal form, or we're going to cancel the escrow. Those are the two ways to get out of the deal. The seller has some responsibility, so customarily it's 7 days unless we write in something different. And, you know, natural hazard disclosure, any government reports, including city reports, if there's any sale or lease equipment. We talked about all these things before, so now this is the place where it says we got the timelines to get that all done. If you're representing a seller, it's best to get that stuff, normally when I'm representing a seller, I'm getting that at the time in which I'm taking, shortly after I'm taking the listing, or giving them the package to complete some of the forms when I take the listing, so I can get them back immediately. Transfer disclosure, statement of seller, all of those things are required. We talked about the representative capacity before. If it's, the seller is an entity, a trust, then they need to, they're not a person, so they have to show that they have the right to sign for that organization. So more stuff that the seller has. Now, if the buyer does not give the seller certain information, then the buyer can give the seller a notice to perform. So if on day 8 you don't have all the things you're supposed to have for the seller, then you can give them a notice to perform. Most times we don't do that. We're not that strict. We kind of work on good faith and work it, but you do have the option to do that. Michael, you have any? Yeah. So notice the seller to perform. That's just a notice. The seller always has the right to choose not to, and then that's a breach of contract, and then the buyer has a right to cancel. So there's always both sides: perform, notice, choose to perform, continue the transaction; choose not to perform, transaction may end. Buyer. Typically the buyer has 17 days because they have more stuff to do to investigate on the property, but you can write in a different date. Any inspections, investigations, everything that the buyer needs to do needs to be done in whatever time is specified in 14B1. Once the buyer completes all those investigations and inspections, then they can request repairs from the seller. Since it's an as-is transaction, the seller does not have to do that, as we said before. But on the form, you can submit that. In Section 1, you can ask the seller to make repairs, give a credit, or reduce the price. Section 2 is where the buyer responds to the seller's request, the seller's response. And then Section 3 is the culmination, so the buyer can agree to accept the seller's final position or can try to renegotiate, go back in for another negotiation. So when all of that is done, if there's no agreement, the buyer has a right to cancel. So there are a number of spaces along the way that the buyer can actually cancel if things don't work the way that they think it should work. We talked about the contingency removal form. That's the way to remove the contingencies, and the cancellation form. In the case where a seller gives a buyer paperwork after the time frame, then the buyer has 5 days beyond that to get the response back. And if there is no response, we'll talk about that later. If there is no response, we talked about it previously. Martine had mentioned something about active removal. So the way the contract works is it's actually active, which means that if the buyer or seller does not take action, then it continues. So if we don't remove, if the seller does not force the buyer to remove the contingency, then the contingency just remains in place. So for our buyers, I always like to operate in good faith, but sometimes things are being worked through, and so we may not release the contingency right away. And most of the time, when the seller then forces it, if it's getting too long, then that's when we know we have to give some releases, contingency releases, and only reserve the ones that might be related to the particular action that we're waiting for them to complete. Does that make sense?
I think so. It's a little confusing with me.
Ask the question, make sure I said it clearly.
So, just can you make that a little shorter about contingencies and how they're in place even though there's no
Okay, even though, okay, what that means, let me try it a different way. So, you have a buyer's home inspection. You have a property inspection, right? The property inspection needs to be completed and released within 17 days. So, at day 8, you get your buyer in there, you do your property inspection, and then you say, okay, I see some repairs. My buyer wants some repairs done. So then you submit the repair request. Repair request gets submitted on day 15. They get back to you on day 17. Well, day 17 is technically the day that you're supposed to remove the contingency, but you're still in negotiation, right? So unless they tell you, give you a notice of buyer to perform, or they tell you verbally, I need you to release a contingency, that contingency will continue. So your what that means is your buyer's deposit that they pay it's still available back to the buyer. You're protecting the buyer's deposit as long as you can when you don't release a contingency. Is that better? Yeah. So that's what it means. It's even though there's time frames in place, if one party or the other does not take action to make those time frames firm, they will continue.
Denise, for those that are in our viewers, can you give us a good definition of what contingency means?
Yes, okay. A contingency is something, an act that has to occur. If that act does not occur, I said that incorrectly. Let me back up for a second. A contingency is a way for a party to not be committed to a transaction unless a particular action occurs. Does that make sense? That's the best way I can think of to present it right now. If you have a different way to offer that, Michael, okay. Okay. Yeah, so, there you go. Okay, we've gone through that. Removal of contingencies, we've talked about that. Okay, we talked about that. Notice of buyer to perform. So in the case I alluded to that there's a document. So now we're at day 18 and the title report has been out. The buyers reviewed it, but we haven't released the contingency for the title report. We haven't said the title report is good, so we no longer will back out of the deal because of the title report. So in that particular case, if it's day 18 and you haven't done it, the listing agent can say, we're going to give you a notice of buyer to perform to release that contingency. Most of the time the agent is going to tell you verbally, hey, I need you to get that in. If you then and the agent aren't on one accord and you let that draw out, then they can give you that notice to perform. And that notice says that you have 48 hours, that's the default time frame, to reply back to release the contingency. If you don't release the contingency, then they can give a notice of cancellation because you're in breach of contract. Does that make sense? Yeah. Most of the time it doesn't go that way, but it can. When it starts getting to that kind of paperwork, you know you're in trouble because you're fighting now. You're really fighting. Did you have a question for you? Okay. Seller's right to cancel, just like buyer has a right to cancel. If the seller doesn't do certain things, then the seller also has a right to cancel. California law says that either party that's in breach has the right to cancel on the other. And the purchase agreement lost my train of thought for a second. Okay, yes. So where I was going with that is the contract basically establishes all the protocol for this, so it's no mystery. The contract clearly spells it out. And we talked about this. In either case, both parties would have to do a notice to perform. There's two separate forms, one for the notice of buyer to perform, one for the notice of seller to perform. We talked about the time frame. Covered that. Okay. Once the buyer, of course, removes a contingency, then they no longer can come back on the seller for that particular item. So everybody's clear on that, right? Okay, close of escrow. If you're in a transaction where you've removed all the contingencies and both parties are ready to close, but for whatever reason you have a seller, maybe that let's say the seller was selling their house and they were buying another house, and that other house let's say it was delayed closing, and that wasn't a seller contingency to the transaction. And so now the seller's like, oh, I can't move out, I can't move out, I can't move out yet. So all the conditions have been satisfied, but the seller won't move. So then you would have to put a demand to close on the particular transaction. And you use a demand to close for escrow because a notice to perform doesn't tie anything to the liquidated damages, but the demand to close does. And so depending on who the breaching party is, would determine who's gonna, if the buyer's gonna get their deposit back, or if the seller's gonna get the deposit. But the deposit is addressed in the demand to close, not a notice to perform.
So how many days is the demand to close?
The demand to close is normally 3 days. I believe it's, I apologize, 3 days or 2 days, I forget which one the default is.
Okay, so in order for a seller to actually cancel an escrow, how many days do we have total?
Once the notice of cancellation is
From the notice to perform.
okay, from the notice to perform, a buyer has normally 48 hours, the 2 days after the notice of buyer to perform is submitted. You have 2 days after that to then respond. If you don't respond at the end of that time, then they can then go to the notice of cancellation. So if the notice to perform is 2 days and the notice of cancellation is 3 days, then that's about 5 to 6 days, because each form is the day after. So the day after the notice of buyer to perform would be 2 days, and then the notice of cancellation is issued. And then if it's 2 or 3 days after that, then it would be 4 or 5 days after the first document is issued if there's going to be a cancellation. That's the fastest it could be done.
Right, the reason I wanted that to be very clear to you guys, because usually when an agent wants to threaten you, they will say, well, I'm going to cancel the deal. Okay, and then you kind of get freaked out because you really don't know how much time you really have in order to perform. But basically, with Denise's example, you have about a week in order to get yourself together. So don't let them scare you when they say that they're going to cancel the transaction. They got to jump through a few hoops before that actually happens.
Yes. Yeah, and the demand to close is 3 days. All of a sudden I couldn't remember if it was 2, just like the notice to perform, or yeah, so it's 3 days. So very good. Effective cancellation on deposits, that's the most important thing to the buyer. If the deal falls apart, are they going to get their money back? The form is pretty specific on that. The cancellation form allows the parties to, if there's confusion, the parties can agree to on dissolving the transaction, but they also can decide that we are in disagreement on the deposit. And so they can kill the transaction, but then they have to go through mediation or arbitration to decide how the deposit is going to be dispositioned if there's some concern about that. If a party refuses to sign the documentation on release of the deposit, then after a certain number of days, 10 days, I'm on the wrong slide. Oh, okay. So one of the things about the deposit, let's say that they're fighting, one party wants to be unfair to the other, then they can just not sign. Well, there is, after about 10 days, escrow can go ahead and release the funds to the party that requested them if the other party, so if it's the buyer that's requested it, if the seller does not respond to escrow's request within 10 days, then they can release it. That's one of the particular situations in which they can't release it. Sometimes parties disappear and they're non-responsive, and so we just need to know how to handle that in that particular case. If someone objects to that in that 10-day period, then they have to continue to hold the money. But if there is no objection, then they can release it. And if the party who chooses not to release and they know that they're not operating in good faith, then they can be, then they can end up not getting their attorney fees, etc., covered if they have to go to mediation or arbitration. Final verification of condition. We all know that at the end, 5 days prior to closing, we want to have a final walkthrough. It allows the buyer to make sure the condition is in the property is in the same condition at the time in which they made the offer. It doesn't open up any other conversation, just to make sure that that's the case. So the buyer doesn't have a right to cancel under this clause. The buyer has the right to make sure. And if by chance it is not in the condition, then they can invoke some of the other rules, which is breach of contract, etc., identified in another paragraph, to then go after the seller to try to get those things taken care of. For the repairs, we want to make sure that those are always done before the final walkthrough, just so you can verify that they've been done in good workmanship manner. The seller can perform the repairs themselves. If they hire someone else to do the repairs, then you can request receipts from the seller to verify that the work was done. Yeah, because you and I, we're not building inspectors, we're not contractors. I don't know, maybe some of you are, but most of us are not. So you can request those from the seller. And just put the agent on notice up front that you're going to want those. Because everybody is not informed on the contract, so we need to then tell them what we expect of them so there's no confusion. But you wait until after you get under contract. Yeah, and so one of the things that the next thing is prorations, which escrow does. And the bottom line they have to do that is because if it was a rental property and the tenant, and you're going to close on the 10th of the month, if the tenant's already paid the rent through the end of the month, who's entitled to what? So escrow will automatically prorate based on the date of closing. So the seller would get the 1st of the month through the 10th of the month, and then the buyer would get a credit for the 11th of the month through the 30th or last day of the month. So escrow just automatically handles that. In the case of Melrose, which that's near and dear to your heart, there's no credit for Melrose. Supplemental tax bill. Escrow prorates based on the existing tax bill. So the rule of thumb is 1.25% of the purchase price. Divide that by 12, that'll tell you about what the monthly amount will be. That's not what's going to be prorated. The existing tax bill is typically going to be lower. So the buyer will get a supplemental tax bill later. And that supplemental tax bill will make up the difference between what they purchased for, or what the new assessed value is and what the old assessed value was. The difference, they'll bill it in 1 or 2 supplemental bills later. So the reason why we give the buyer that notice of your supplemental property tax bill, which sometimes is now in the NHD, is so that they're not surprised. Because if it's a big difference, if the seller's owned the property for 30 years and now you're coming in buying it, that seller's basis or their tax assessed amount is very low. So it's going to be a big number then that they're going to get hit with later, so they need to be prepared.
Really?
Mm-hmm.
So that's the difference? How long they've been?
Yeah, in California with Proposition 73, I'm getting older and some of the numbers kind of get away from me. But anyway, the county is limited on the amount that they can increase the property tax bill every year, and it's 1%. And so if that's the case, if you own it for forever, appreciation may have, or the appreciation may have been greater than the 1% a year. So when that happens, 1.25% of 500,000, and they bought it at 100,000, that's 400,000 that has to be made up. And so that means the bill's going to be kind of large. Yeah.
Denise, quick question.
Yes.
So the seller pays their taxes, right? Or their whatever they're paying taxes.
I'm sorry.
So on the buyer side, they have their closing cost,
Mm-hmm.
so they have to pay up front 4 months, 6 months, whatever it is, right?
Mm-hmm.
So at that time, when they pay the 4 months or 6 months, they're paying for the whatever the seller's paying for taxes?
No, the payment for the buyer for the loan side is calculated based on the
Purchase.
new value versus on the purchase price. Only for the tax assessor, the tax collector piece, that is calculated based on the existing property tax bill. Does that make sense? So the lender, when they qualify the buyer, they're qualifying the buyer based on the future tax assessed value, the estimate of the future tax assessed value. Because that's the only way for them to make sure that they know what the buyer's true debt to income is going to be based on that true payment. Great question, great question. The other thing just to note is the prorations are based on 30 days, a 30-day month, regardless of how many days are in the month. Sometimes for my own fun, I go try to recalculate or calculate, make sure I get the same number that escrow gets. So I'm anal that way at times. Okay. Compensation. The slides are going to get a little dicey here because I ran out of time to kind of thin them out. But the residential listing agreement, if you're taking a listing, at the time of listing, it establishes what the compensation is going to be to the brokerage. So you and the seller will come to an agreement on that. If by chance if by chance there is no, let's say there's no listing, and you want to ensure that you get paid, let's say you're approaching a seller with a buyer, then you could do a cooperating broker compensation agreement. Also, you can submit that if you're, like in the particular case I just did a transaction, of which there wasn't, it's not in the MLS. Commercial transactions aren't always in the MLS. So I want to make sure that I know what my what the brokerage fee is going to be. And so then you can submit a cooperating broker compensation agreement so it makes sure both parties know what the compensation is going to be to each broker. And we know that the listing agent, when they take that, they then offer to the cooperating broker a piece. And so that's kind of how that works. Buyers, anybody did a buyer's representation agreement? Okay. And with those, then how does that work, Michael?
As far as?
For the, with the commission, is the buyer agreeing to pay you the commission?
No, on the buyer's representation agreement, what usually happens is that the buyer only has to pay compensation when the seller doesn't have to pay. So the majority of the time, the seller will be paying compensation, especially if it's in MLS. If it's not in the MLS, then if it's outside, then maybe the buyer will be responsible for paying it.
Very good. And that's because sometimes people do the buyer agreement because they want to make sure the buyer is committed to me as an agent, Michael as an agent, when we take our time to go out and show them. So that's why you get the commitment that if I find you a property and it's not in the MLS, then you still agree to pay me.
Right.
We know that at close of escrow, that's when the commission is paid. If the escrow doesn't close, commission doesn't get paid. And once the seller signs that agreement to pay commission, they can't revoke it. Commission is not one of the negotiable terms of the agreement. Once that is set, buyer and seller, they have negotiable terms, but the commission is really no longer negotiable unless the brokerage chooses to open that up as an option. Real estate broker, we have the brokerages, our brokerage is Realty Executives, all cities. We have a responsibility to the transaction. We're not parties to the transaction. So we coach and guide our clients through the process. We do a visual inspection to make sure that anything that we can see in the property, we annotate it, and then our client gets to see that as well as the seller gets to see it. And those are pretty much it in terms of our responsibilities. Since we're not party to the transaction, we don't give any tax advice, we don't give any legal advice, even though we may have some notional idea, and we may tell the person, oh, you know, I think it's this way, but you need to contact your accountant, your lawyer, your whatever other party that's their profession. Representative capacity, you don't need to worry about the slide. I'll tell you back to our original conversation. If it's something other than an individual, Denise, Janine, then that entity, a trust, a corporation, an LLC, has to have a party that's designated to sign for it. That's all that means. We do that form so we then can identify who's responsible for signing for that, and then we need the documents that show that that person has the authority to do that. joint escrow instructions. What, please keep me aware of the time.
You're good.
Okay, yeah, very good. So, as I mentioned in the beginning, we have escrow instructions that are generated once the transaction, once the buyer and seller agree to do business together, there's an agreement. This says that escrow then will go out and execute that agreement. They're the neutral third party. They don't change the terms, or they're not a party to the transaction. They're only executing what buyer and seller agree to. And that's pretty much it. One of the things escrow, the buyer's deposit needs to get to escrow. Now we're doing, a lot of people are doing the wires in, so that goes by pretty quick. Escrow instructions should come out typically within 5 days, but most of the time they don't. That's my experience. It takes a little bit longer. We already talked about the brokers aren't party to the transaction. If the buyer doesn't make the deposit, then of course escrow would let the selling agent, the listing agent know right away, because then that is in breach, and then there's another opportunity for the transaction to cancel. Remedies for breach. The law says that if there is a breach, then the buyer's deposit could be in jeopardy if it's a buyer breach, and the contingencies have been removed. The other thing to be noted is some buyers like to get cute with things. I call it cute. So they may try to throw some clauses in there for early release of deposit. Deposits are non-refundable. We don't want to deal with any of that stuff, because what it does is it makes it gray, very gray. The rules don't say that it's not illegal, but it just makes it very difficult to establish what's going to happen with that deposit. So if you're representing a seller, don't allow anyone to insert any additional language that talks about the deposit and refundable, non-refundable, etc. We talked earlier about, in the case of the liquidated damages, if it's a 1 to 4 unit building and it's going to be owner occupied, then the liquidated damages is 3%. If the buyer only put up 1%, then that's all the seller's going to get is 1%. So it's up to 3% of what was paid. It's 3% or whatever was paid if it's less than 3%. If it's a non-owner occupied, if it's a non-owner occupied property or more than 1 to 4 units, then the liquidated damages is actually the deposit. Yeah, so that's something to be very mindful of. If the seller wants access to the increased deposit, then we talked about they need to do the liquidated damages addendum, because that form says basically that the increased deposit is now also going to be subject to liquidated damages. Mediation basically is just a third party that's going to come in. Mediation is a part of the contract that's non-negotiable. So the mediator is not empowered to solve the situation for you. They're just designed to help facilitate you to get to an answer. It's not optional. So signing the purchase agreement by default says that you're going to mediate if there's a problem. If a person goes out of protocol and chooses not to mediate and they want to go straight to arbitration, then typically if that person is found to be the losing party, the winning party, their charges will not be reimbursed. Their attorney's fees or whatever will not be reimbursed because they didn't follow the protocol in the contract. The CAR has a mediation center, and that mediation center is normally the default for handling issues. The buyer or the seller has the right to go to any other mediator that they choose. If they are fighting over which mediator, then by default it goes back to the CAR mediation. On the arbitration, it's a third party. It's not a judge or anything like that. There's no jury. It's a private party. Buyer and seller pay for their own, and they what the arbitrator comes up with is binding. important. Just looking for the key things that are important right now. Okay, from mediation, from arbitration, anything related to foreclosure, or eviction, which is unlawful detainer. You can go to small claims court, that is one of the exceptions for arbitration. If there is going to be a suit, you need to file it right away. Okay. Dispute reservation of actions. In this particular case, once you have a suit, then you file what they call a lis pendens. That puts a cloud on the title, and the lawyers handle the rest. But we don't want to get to that. That means we've got a problem. We want to try to solve every action we can before you get to two parties fighting for this. And typically, if it's at this point, it should be something that's major, that you know, both parties feel like they're injured because they can't find another property like this or something like that. Okay, very good. I think at this point, we have a few more slides to go, such that, okay. Very good. So dispute resolution between brokers, basically brokerages, if they have if their agents have done something particular that they think is a problem, then typically brokerages will, broker to broker will go try to handle any issues associated with that. Selection of service providers, Michael already shared with us before that selection of service providers is, we cannot dictate who buyer or seller will use, so just be mindful of that, and we can try to use incentives. MLS, basically, that's the venue we use to market the properties. Attorney's fees, if whichever party is the winning party, then the other party is required to pay their attorney fees. Assignments, the contracts is not assignable. That's the way it's written. Some people try to put assignments in for buyers, etc., but contract's not assignable. Equal housing opportunity, hey, be fair to everybody, keep ourselves above the law. Not above the law, within the law, excuse me. Let's see. Your offer can be withdrawn if you choose to. If the offer is withdrawn, you would use the withdrawal of offer form. Most of this stuff here is the nitty-gritty stuff we've already kind of handled. These slides here are just kind of definitional by nature, but the most important stuff we've gotten, which is the contingency, the time is of the essence period, and the investigation information. So confirmation of agency relationship, we already know that. That's part of our package. Time is of the essence. Everything about the contract. We have timelines. We have a timeline for close of escrow. We have a timeline for contingency period. We must move fast. Definitions, I'll let you look at those on your own. Expiration of offer. Basically, there's a default in there for offer expiration, 3 days. You can write in anything that you want. If the seller does not respond within that time frame, normally you should get a rejection of offer or something like that, but you identify to the seller how much time you're giving them to make a decision on your offer. The buyer will sign the offer. We talked about the addendums if there's extra buyers that don't fit in the previous lines on the contract, or if there is an entity or a trust purchasing. Acceptance of offer. The seller will sign if they're accepting it, and normally acceptance, as long as it's received by the agent, we write our name in, then once the agent received it, it's considered received on the buyer side. Yeah, so confirmation of signatures on the, we dealt with signatures on the buyer side, same thing applies to signatures on the seller side, and then confirmation of acceptance. We typically like to get the confirmation of acceptance back, but you don't have to get the acceptance back, because once it's received by the other agent, that is sufficient, and the paragraph actually states that, but you can get the confirmation if you like. I like to get the confirmation signed back. Accepted. Broker signature. Okay, the broker's going to confirm agency relationship. Agency relationship, we talked about the cooperating broker. Everybody wants to get paid, not everybody. The brokers want to get paid, and therefore we want to get paid. We know that our license number has to be disclosed on everything. The escrow, there's a box on page 10, the escrow acknowledgement. So escrow, once they get the contract, they'll sign their section, let us know what their license number is, etc., and then send that back saying that the contract is officially in escrow and they've started. There's a box on there that the listing agent can check saying that they presented the offer if the buyer's agent, us, doesn't present it ourselves. And then rejection of offer. Most of the time these don't come back. I find that the attention to detail in the industry is limited at times, so most of the time I don't get a rejection back. But technically, they should give us a rejection back. And that's the end. Thank you. Thank you. Session 3, yes, I wasn't sure, but we made it. Okay.
Denise, go here. Did she do a fantastic job? I mean, it took 2 parts, but it was awesome. And she doesn't know.
That's one way to end it, man. There's nothing in the screen.
She doesn't know she's going to do it again. But thank you so much. We really appreciate it. Thank you so much. You're awesome.